This is a reviewer for political law covering due process and touching on police power, overbreadth, doctrine, void-for-vagueness, facial challenges, and the chilling effect. So, first, what is due process? Obviously, there are going to be two aspects of it, the substantial and the procedural. I say obviously because at this point we should know this, right? We should know this. The bar is in 6 months. Okay, so you have your substantial and you have your procedural due process. Substantial due process is when there is a legitimate government purpose and the government is going to use reasonably necessary means in order to enforce or achieve this purpose. That's substantial due process. Procedural due process is going to be distilled essentially down to notice and the opportunity to be heard. By who? By a competent and impartial tribunal. When you talk about competency, what should be triggering in your brain right now? Jurisdiction. Okay? So if the issue has something to do with an administrative matter, if you're going before an administrative tribunal, does the administrative tribunal even have competency to hear that issue or to hear the cause arising out of, the conflict? Because if it doesn't, then that tribunal is not competent. So, and what happens if it's not competent? Then it doesn't have jurisdiction. If it doesn't have jurisdiction, then it's not competent, and then any procedures before it would be void. So, that's due process, the two aspects of it. Substantial, legitimate government purpose, and reasonably necessary means. Procedural, notice and the opportunity to be heard. That is going to take different forms for different kinds of proceedings. Is it civil? Is it criminal? Is it administrative? Is it, the admin, but then it's in front of the labor arbiter? It's admin, but it's for schools, right? There's different standards there. Just remember, ang tibay, right? The cardinal rights for administrative due process. Cardinal something. There was another adjective there that was just like overkill. Anyway, the 7 there. But in general, opportunity to be heard. In labor, what's that going to be? It's going to be your to notice and hearing, right? So, from substantial due process, you tie that now into police power. And in general, what is police power? It's inherent power of the state in order to regulate. How? Through a lawful subject and by employing lawful means. Police power, lawful subject, lawful means. You have both of those, then it's fine for the state to infringe upon fundamental liberties, right? Section 2 of Article 3 would give, the right to life, liberty, and property. So they're not absolute because there can be lawful regulation of these rights. Now, when you're talking about life, liberty, property, I can't think of that many examples where the state is going to regulate your life, but liberty for sure, right? And property as well, because when we talk about property, we're not just talking about property in the property law sense, which would be things that are susceptible to ownership. It's susceptible, but you can have ownership over it, right? And titles. We're also talking about vested rights. So in the sense here of the deprivation of property could be a vested right over something, But that can be the subject, the subject. That can be, no, not the subject, the object of an exercise of police power, so long as there is a lawful subject and a lawful means. So the tests to see the standard of lawfulness would really depend on the right being talked about. So that's why later on, actually not in this one because I think it'll get too long if I get into it here, but we'll talk about the standards of review, which would be strict scrutiny, intermediate or heightened scrutiny, and the rational basis test. But just to quickly touch upon it, the rational basis test is the same thing that I just said. It's the most default, most lenient, general thing for the exercise of police power. Is the exercise of police power valid? How do you know? Under the rational basis test, there has to be a rational relation to a legitimate government purpose. And what does that sound like? Sounds like substantial due process, a legitimate government purpose, reasonably necessary means in order to have police power that is lawful subject, lawful means. Okay, Now, again, the tests would change depending on the right. We'll get into that in another thing. But I just want to say it now so it sticks in my head, because I keep forgetting the key words. Like, I know the levels, but I keep forgetting the key words. So strict scrutiny is going to be a compelling state interest, narrowly tailored, what is involved, fundamental rights, freedom of speech, right to vote, or a suspect class such as religion, race, national origin, or citizenship. Intermediate or heightened scrutiny, it's going to be a sensitive classification, gender, and then legitimacy of birth or illegitimacy of birth. What does the government need? It's an important state interest, not compelling, important objective, substantially, and the classification or regulation has to be substantially related. So, important objective, substantially related. And then the last one, rational basis, would be rational relation to a legitimate government purpose. Okay. Now, as long as it's under that general rule, police power laws are assumed to be valid. So, when can you say that a law is not valid, though? What would you apply? Or, like, what are some tools you can have in your belt to say that this may not be valid? Let's talk now about void-for-vagueness and the overbreadth doctrine. So, the void-for-vagueness test, or the void-for-vagueness doctrine, my dog is running, she's so cute. It's when the test is to see, like, is someone who has average, can someone who has average intelligence, obviously not me because I just fucked that sentence up, can someone of average intelligence know what conduct the law or the regulation or the government action is actually seeking to regulate? Okay? Can they tell when they read the statute or the regulation, can a person of average intelligence know what conduct is sought to be regulated here? And if they can't, that cannot be a valid exercise of police power. Why? It would impair the right to notice under procedural due process. Because under the right to notice, and you'll see this in the different enumerations on the different kinds of procedures, right? The admin, your criminal, blah, blah, blah. But relate this to the rights of the accused to be informed of the charges, right? Or even in an administrative due process, there has to be notice of the conduct that you're being charged with, right? Say loss of trust and confidence with a rank and file employee, which would require for dismissal. What? There has to be actual proof that the rank and file employee was involved with the incident that caused the loss of trust and confidence. Actual proof, I can't remember the quantum of evidence there, but it's different from the managerial trust and confidence employees, because there all you need is, I think, sufficient basis that there is a reason to lose trust and confidence. Like, you don't need to prove it so much, but that's the difference there. Sorry, just tangenting. Okay, but yeah, so void for vagueness, if a person of average intelligence does not know what conduct the law is actually seeking to regulate, this would impair the right to be notified, because you don't know what you're going to be charged with, or you don't know what you're being charged with. And this is bad because it would give too much discretion to law enforcement authorities to declare what is illegal or what is unlawful, okay? So if it's too vague, then you as the person don't know what you did wrong. And if you're the law enforcement authority, you have this extension of discretion. You have too much discretion to determine or to declare what would be unlawful under this regulation or the statute. Now, the void for vagueness doctrine usually applies in penal and free speech statutes. So if it's free speech statute, what test are we going to look at again? We're going to look at the strict scrutiny, because free speech is a very highly preferred right under the hierarchy of rights. But also penal statutes, and this is recent, okay? So for free speech, you're going to if it talks about free speech, you're going to have the test of strict scrutiny. And then you're going to talk about void-for-vagueness doctrine. And just remember, it's also going to come up the overbreadth doctrine. Okay? And it can be for penal statutes also, but we'll talk about that in a bit. So let's go to the overbreadth first. So if the void-for-vagueness doctrine is when a person of average intelligence doesn't know what they can be charged with, and then this would impair their right to notice under procedural due process, the overbreadth doctrine talks about how the means employed by the regulation are too broad. Okay? So remember that substantial due process, legitimate purpose, and reasonably necessary means. So the overbreadth doctrine would talk about that now. The means, how the conduct is, how the state seeks to regulate or to achieve that legitimate state purpose, right? Yeah. So, overbreadth, then the means are too broad. The void-for-vagueness, the definition is too broad. It's too void. Damn it! It's too vague. God damn it! I keep fucking that up. So overbreadth, the means are too broad. So if the regulation or the government action is seeking to protect against unprotected conduct, which is, a legitimate state purpose, you want unlawful things or unprotected speeches to be regulated. You don't want people to say hate speech, right? That seems like a legitimate government purpose to prevent hate speech, right? But if the means employed are not reasonably necessary and instead they are overly broad, then instead of just covering what would be unlawful conduct, crimes, or unprotected speech, then these overly broad government actions, laws, regulations might sweep up into the umbrella of what can be punished, conduct or speech that would otherwise be lawful or actually is lawful. So that's overbreadth. That's void-for-vagueness. You're going to come across these when you're talking about free speech, and you're going to apply the strict scrutiny test, which is going to be highest level, fundamental rights, freedom of speech, and then also right to vote, suspect classes, religion, race, national origin, citizenship. But right to vote, suspect classes, etc., you don't really apply the void-for-vagueness or the overbreadth doctrine because that's really more for free speech. And what are you looking at here? You need a compelling state interest, like stopping hate speech. That seems compelling and narrowly tailored. So the means here are going to be overly broad if they're just medium tailored. They got to be narrowly tailored, okay? So that the conduct that is not unlawful or the speech that is not unlawful, actually the conduct that is not unlawful, and the speech that is protected by the Constitution would not be swept up together and lumped in together by with the unprotected conduct like crimes or unprotected speech. And then it won't be void for vagueness because we would also know what the law is seeking to regulate, and discretion won't be given to law enforcement authorities to declare what is illegal. So now let's talk about why penal statutes are covered here now under the void for vagueness doctrine. So this used to be limited only to free speech, but look at the cases of Decini versus Secretary of Justice, and then the same rationale was reinforced in Calleja versus Executive Secretary, and these cases involved cybercrimes, right? So here in Decini versus Secretary of Justice and Calleja versus Executive Secretary, the court said that penal statutes may be challenged on their face, on your face. I'm doing the Chapel Roan thing, the face to face. Anyway, penal statutes may be challenged on their face if they significantly challenge freedom of expression. And why do we allow this? Because we want to prevent the chilling effect that people may restrain from doing their otherwise lawful actions out of fear that their actions may be taken as criminal under the overbroad statute. Again, before void-for-vagueness and overbreadth were limited to free speech, but now in 2024, Decini versus Executive Secretary, Decini versus Secretary of Justice and Calleja versus Executive Secretary, he's talking about cybercrimes. Basically, penal statutes can be challenged on their face if they significantly challenge freedom of expression, because we want to prevent the chilling effect where people would restrain themselves from doing otherwise lawful actions or conduct out of fear that their actions may be taken as criminal under the overbroad statute. So when there's overly broad wording, there's a potential of harm where legal or worse, even legal conduct, or even worse, protected expression would be taken as criminal or unlawful under this overbroad statute. So then the courts can strike down that statute for being overly broad and vague. So if the law enforcement authorities have to be the ones who interpret the statute to see what is illegal or not, then this is too much discretion to give them. It would be prone to abuse, and you can't call this a valid exercise of police power, which, again, what does police power require? A lawful subject, a lawful means. And this lawful means has to be reasonably necessary. It has to be reasonably necessary. And in the case of free speech, or the right to speech, in the case of protected speech, what is reasonably necessary is a narrowly tailored, tight fit between the means and the end, and that end is a compelling state interest. So you need some extraordinary justification to pass the strict scrutiny test. And obviously, from how terrible the names are, void-for-vagueness and overbreadth, these are not going to pass that test because they can't. They sound bad already. So, there. So, the legitimate purpose of anything that seeks to curb unlawful speech, yeah, that is a legitimate purpose. But you can see how the reasonable necessity can be so strictly and narrowly defined in relation to this very preferred right. So, going back to the hierarchy of rights, the highest level is given of standards of review is given to it's given to fundamental rights like freedom of speech, so you apply strict scrutiny, compelling state interest, narrowly tailored, a tight fit between the means and the end. Now, let's go to facial challenges and chilling effect, and then after this, cases? Okay, so yeah, a facial challenge. So here we're going to quote Decini versus Secretary of Justice, where the court distinguished between a facial challenge and an as-applied challenge. So in an as-applied challenge, the petitioner who claims a violation of his constitutional right can raise any constitutional ground, such as absence of due process, lack of fair notice, lack of ascertainable standards, overbreadth, or vagueness. Boom, we've circled back. Here, one can challenge the constitutionality of a statute only if he asserts a violation of his own rights. So that's an as-applied challenge. You can only say, hey, I don't think this statute is constitutional. In an as-applied challenge, you can only do that if you are asserting your own rights. What am I thinking of now? What's his face? Falsis versus Civil Register, right? Part of that was that there was no, not standing, but basically, like, since he didn't file a petition, or he didn't apply for a marriage license, that sort of affected his standing to challenge the constitutionality of the statute, right? So an as-applied challenge would prohibit one from assailing the constitutionality of a statute based solely on the violation of rights of third persons not before the court. The rule of the as-applied challenge is also known as the prohibition against third-party standing. Yeah, standing. I'm talking about standing. Now, this rule also admits of exceptions, and one of these is the facial challenge. So a petitioner may mount a facial challenge to the constitutionality of a statute even if the petitioner claims no violation of their own right under the assailed statute when it involves free speech on the grounds of overbreadth or vagueness of the statute. So that's why we're here. We're talking about that, right? So facial challenge can prosper in free speech cases or in penal. If you're challenging a penal statute that seeks to regulate speech, okay? Not all penal statutes. You can't just be like, I think that crime should not be a crime, but I haven't committed the crime yet. Well, actually, I don't think that is a defense if you were charged with committing a crime saying like, I think this should be legal. Never mind. Forget what I just said. So, yeah, a petitioner may, for instance, mount a facial challenge to the constitutionality of a statute, even if he claims no violation of his own rights under the assailed statute, where it involves free speech on the grounds of overbreadth or vagueness of the statute. The rationale for this exception is to counter the chilling effect on protected speech that comes from statutes violating free speech. A person who does not know whether his speech constitutes a crime under an overbroad or vague law may simply restrain himself from speaking in order to avoid being charged with a crime. So, I mean, hopefully you're not going to be one of those people who wouldn't know whether, they're just, everyone's too politically correct this time, or like if they're actually giving hate speech. Don't be that person, But if you are that person and there is an overly broad or vague statute, then you might prohibit yourself from saying what would otherwise be protected speech, but honestly, it's still going to piss people off. But it might not be illegal, but you would be restrained from your right to be an asshole, I guess. And, we don't want that chilling effect. But, okay, political speech especially, right? When are you validly voicing criticism against the government or against government action, government regulations, and when are you being a dissenter, When does it cross the line? If you don't know where that line is, a lot of people would err on the side of safety, and that would be the chilling effect, where the fullness of expression that would and should be protected is not reached because people would restrain themselves for fear of crossing a line that they do not know where it is drawn. Okay? So a person who does not know whether his speech constitutes a crime under an overbroad or vague law may simply restrain himself from speaking in order to avoid being charged with a crime. Thus, the overbroad or vague law would chill that person into silence. So that is under Decini versus Secretary of Justice, the as-applied challenge, the facial challenge, and the chilling effect. So when the as-applied challenge considers only extant facts affecting a real litigant, the facial challenge would involve an examination of the entire law and the pinpointing of its flaws and defects, not only on the basis of its actual operation to the parties, but also on the assumption or prediction that its very existence may cause others not before the court to refrain from constitutionally protected speech or activities. So, as applied challenge, the standing is based on a violation a violation of your own rights. The facial challenge, it doesn't have to be your own rights. It's an exception against the prohibition against third-party standing. It would be, it involves free speech on the grounds of overbreadth or vagueness of the statute. And then what happens is, if it's an as-applied challenge, the court would consider only the extant facts affecting the real litigant before them whose rights are violated or threatened to being violated, right? If it's threatened only, that would be, I want to say declaratory relief, but please do not quote me on that because I'm very bad at drama. Anyway, but if it's a facial challenge, then the court would examine the entire law to pinpoint its flaws and defects to prevent the chilling effect that could affect not just the person before them or the petitioner before them, but anyone, because we're talking about protected speech, protected activities here. The facial challenge is a narrow exception to the general rule that there must be an actual case or controversy before the court exercises judicial review, right? So, remember the requisites for judicial review? See, it all ties together. Like, when you can make the little map in your head for all these doctrines, it becomes a lot easier than just memorizing it. So I would recommend doing that. So anyway, judicial review, right? And remember, under the Constitution now we have expanded judicial review because we don't just have for the actual cases of controversy, blah, blah, blah. We also have gut allege, right? Grave abuse of discretion amounting to lack or excess of jurisdiction. So that's expanded judicial review under the 1987 Constitution. But right now, let's just run through it real quick. How do you know if the courts can the requisites of justiciability, that's what it was. The requisites of justiciability for the court to exercise judicial review. You have actual case or controversy. Petitioners must possess locus standi. The question of constitutionality must be the very lis mota of the case, and the resolution of the question is an unavoidable necessity to the decision of the case itself. Okay? So, actual case or controversy, locus standi, lis mota, and lis mota is the last one. So the resolution of the question is an unavoidable necessity to the decision of the case itself. So the constitutionality is the very lis mota of the case. Lis mota? Litis mota? I can't remember. That was a nickname for someone in my law school block. So I can't remember if it's Liz, which was her name, or Litis. Oops. Anyway, I think it was Litis. Litis mota sounds more right, because that sounds Latin. Correct. Anyway. And, earliest opportunity. That's the other one. So, standing, actual case or controversy, so ripe for judicial review, right? Earliest opportunity, and the resolution of the question is an unavoidable necessity. Is unavoidably necessary to the decision of the case itself. So now but now you can see that where does this fall under? These as-applied challenges, the facial challenges, void for vagueness, they apply under actual case or controversy. So if it's not a penal statute that involves free speech, or if it's not involving free speech, and you try and do a facial challenge, you can't. Why? There's no actual case or controversy. Okay? Indeed, on its face, invalidation of statutes results in striking them down entirely on the ground that they might be applied to parties not before the court whose activities are constitutionally protected. It constitutes a departure from the case and controversy requirement of the Constitution, and it permits decisions to be made without concrete factual settings and in sterile, abstract context. So there's no one could have even been arrested for it yet, and you can still on its face say, this should not be allowed constitutionally. And then it's also, again, it's a exception to the prohibition against third-party standing. In Southern Hemisphere Engagement Network versus Anti-Terrorism Council, the court explained a facial invalidation of a statute is allowed only in free speech cases wherein certain rules of constitutional litigation are rightly accepted. The allowance of a facial challenge in free speech cases is justified because the aim is to avert the chilling effect on protected speech, and because the exercise of which should not at all times be abridged. As reflected earlier, this rationale is inapplicable to plain penal statutes that generally bear an in terrorem effect, right? Because you want people to be scared of committing crimes because they will go to jail. And have you seen pictures of Bikutan? It's no good. So, in terrorem effect, to deter socially harmful conduct. So the legislature can even forbid or penalize acts which were formerly considered innocent and lawful so long as it refrains from diminishing or dissuading the exercise of constitutionally protected rights. So we're going a bit long here, but it's still good because these are fundamental concepts, police power, etc., right? So in the absence of actual facts where a violation of fundamental rights is so grievous or imminent that judicial restraint would lead to serious violations of fundamental rights. So, judicial review can still be allowed when in the scenario where the violation of rights must be so egregious and pervasive that almost any citizen can raise the same issue, such as when it's a penal statute covering free speech. Then you would be allowed to do a facial challenge, even if your rights were not violated. Because why? It is so grievous, or it is so imminent, and it is so clear that serious violations could happen against these very fundamental rights. So the exceptions would be when a facial review of a statute is allowed as in cases of actual or clearly imminent violation of the sovereign rights to free expression or its cognate rights, or where, so this goes a bit further now, where there is a clear and convincing showing that a fundamental constitutional right has been actually violated in the application of a statute which are of transcendental interests. The violation must be so demonstrably and urgently egregious that it outweighs a reasonable policy of deference in such instance. So, there. So there are other exceptions, basically. So facial challenge is one exception, and then the other one is the clear and convincing showing that there has been an actual violation of a fundamental constitutional right because of the application of a statute, and this would pique the transcendental interests of the court. So the violation has to be so demonstrably and urgently egregious that, you know, the court has to deal with it now. So the facts there in the second scenario, but we're not really going to go into it because we just want to talk about facial challenge right now, and this is getting loud. So the facts constituting the violation must be either uncontested, or there can be a trial to establish the facts. The basis for the ruling on the second one, so facial challenge, now this one, the basis for the ruling on the constitutional issue must also be clearly alleged and traversed by the parties. Otherwise, the court cannot take cognizance of the constitutional issue. So basically, these are the exceptions where judicial review is appropriate despite the actual despite the absence of actual facts. So this would be first, facial challenge. Second, if it is a violation that is so demonstrably and urgently egregious of a fundamental constitutional right that has actually been violated in the application of the statute, and this would be because of transcendental interest. So facial challenge, transcendental interest, okay? And then the third instance where judicial review is appropriate despite the absence of actual facts is when a constitutional provision invokes emergency or urgent measures. Why? Because by the very nature here, emergency or urgent measures are temporary, and thus allowing it to avoid judicial review, even if it's capable of repetition. Okay, so what are we touching on here now? We're touching on that list of, when can you exercise judicial review? Like if it's moot and academic, but it's evaded judicial review, but it's capable of repetition, right? These are basically when the court can be a trier of facts. Right? No. But that list with the transcendental importance, facial challenges, one is avoiding judicial review even if it's capable of repetition. Anyway, yeah. So where judicial review is appropriate despite the absence of actual facts. We just touched on that now. But I think that would end it for this. So that was, what did we cover here? Police power in general, due process, substantive and procedural, void-for-vagueness, overbreadth, facial challenges, chilling effect. Okay, so just for posterity's sake, we're going to run through it one last time. So basically just covering due process as a constitutional right. First, you have procedural and substantive due process. Procedural due process ensures the fairness of legal procedure and the application of the law. It has two requisites: the right to notice or be informed, and the right to be heard or to present evidence to overcome the allegations against the person. This being procedural due process, would safeguard individuals against being deprived of their life, liberty, or property. On the other hand, substantive due process would scrutinize the content and parameters of the law as they affect individuals. Substantive law protects individuals from any unfair infringement upon their constitutionally protected rights by the government. Okay? So what do you need there? You need a legitimate state interest, and the means must be reasonably necessary. So let's go into some cases here. Do I want to do cases now? How many cases do I have? Oh, there's not so many. Yeah. We'll just do the cases under this instead of making a separate one. First, Anonymous versus Radam. Here, why was Radam denied the right to due process? This case is also under judicial ethics. So it was an anonymous letter complaint where respondent Radam, who was a utility worker in the office of the clerk of court in the RTC of Alamina City, was charged with immorality, and the unnamed complaint alleged that the respondent was unmarried but got pregnant and then gave birth sometime in October 2005. The claimant then complained that the respondent's behavior tainted the image of the judiciary. The Office of the Court Administrator absolved Radam of the charge of immorality, but held her liable for conduct unbecoming of a court employee for stating in the birth certificate of her child that the father was unknown to her, even though she did know. So basically, why was Radam denied the right to due process here? Because what we're going to talk about here is for stating in the birth certificate that her child was unknown, had an unknown father, right? Because the essence of due process in an administrative proceeding, and this is an administrative proceeding, is the opportunity to explain one side, whether through written submissions or verbally. This presupposes that one has been previously apprised of the accusation against her, against him or her, against them, right? So here, they were, the complaint claimed that it was immoral behavior, but instead she was held liable for falsifying the birth certificate, right? Because of the unknown father. So she didn't really know what to prepare for here. So in GSIS versus Court of Appeals, it was ruled that an employee must be informed of the charges preferred against him. So now we're going into due process and administrative proceedings. But that's okay, because it's still under due process. This is going to get long, but that's fine. I'm studying. So GSIS versus CA, it was ruled that an employee must be informed of the charges proffered against him. The normal way by which the employee is so informed is by furnishing him with a copy of the charges against him. The second requirement for administrative due process is that the employee must have reasonable opportunity to present their side on the matter. So to present their defenses, present evidence. And how are you going to prepare your defenses if you don't even know what you're going to be charged with, or you prepare for one thing and they decide on another? So here, Radam was not sufficiently apprised of the additional charge against her on the birth certificate thing. So, she was unable to confront the charge and explain it. She was denied the second requirement, so the reasonable opportunity to present her side. So to hold her liable for a totally different charge that she was unaware of would violate her right to due process. So there you go. Also, as to the judicial ethics portion of this, notice it's anonymous versus Radam. So for lawyers, if you're going to complain against a lawyer, what do you need? A verified complaint under oath if you want to complain against the lawyer, right? So you know who's complaining against you. But if it's for judges and the judiciary, anonymous complaints are allowed, and the Supreme Court is allowed to act on that. So that's interesting. Okie dokie. Connect this also to the case of Leos. Remember the lady who got, she was working for, I think, like, for school. I think it was like state school. No. But I remember where I was when I read the case of Leos. I was having a gin and tonic in Shangri-La, so it sticks in my head. But it's child out of wedlock thing, right? So that's anonymous versus Radam. Second case under due process would be Oka versus Indar. So here, why was Judge Indar subjected to a full investigation despite his non-participation in the proceedings? So we're really looking at whether the requirements of due process have been complied with, even though there was no proof that Judge Indar here personally and actually received any of the notices sent to him over the course of the investigation. And the court said yes, the requirements of due process were complied with. Why? Because what's needed really is only the opportunity to be heard. So some background here, Judge Indar was a family court judge, and then he gave like a bunch of orders for the annulment, but even though there was nothing to show that proceedings were had on the question cases, the docket fees were paid, basically a lot of irregularities, right? So they had to investigate. The Office of the Court Administrator investigated, and so the notice for the hearing for the administrative case for gross misconduct and dishonesty were sent to Judge Indar at his residence. But basically he just didn't participate. He failed to attend the hearing, and he didn't appear. So the court still ruled that there was no denial of the right to due process, and unfortunately it led to his eventual dismissal and dismissal from the judiciary and then disbarment. But the court said the technical rules of procedure and evidence are not strictly applied to administrative proceedings, right? Because when you look at the rules of evidence, where do they apply? They apply to judicial proceedings, right? So if it's an administrative proceeding, it's not strictly applied. Thus, administrative due process cannot be fully equated with due process in the strict judicial sense. It is enough that the party was given the chance to be heard, the opportunity to be heard before the case against him is decided. Otherwise stated, the application of the principle of due process when it's applied to administrative cases is you just have to safeguard the denial of the opportunity to be heard. No, sorry. You have to safeguard against the denial of the opportunity to be heard. So what's required is not the lack of previous notice, but the lack of any opportunity to be heard. So here, it was ruled the judge Indar was given ample opportunity to be heard. Now, the case of Kudia versus Superintendent of the Philippine Military Academy, here, the nature of what's being talked about here in due process is the nature of an administrative proceeding in an academic institution like the PMA, within the context of one's diminished right to privacy. I'll probably touch upon this again in admin law, but so just real quick, here, whether or not a PMA cadet has the right to due process, to education, and to property in the context of the honor code and the honor system, the court agreed with the argument of the petitioner that in the context of the disciplinary investigation, when a cadet joins the PMA, it does not contemplate a surrender of the right to due process, but at most refers to the cadet's right to privacy and to remain silent. So, where a person's good name, reputation, honor, or integrity is at stake because of what the government is doing to him, the minimal requirements of the due process clause must be satisfied. So, the official action must meet the minimum standards of fairness to the individual, and this would generally encompass the right to adequate notice and a meaningful opportunity to be heard. So, yes. Was he denied the right to due process because they resorted to chamber hearings? No. The right to be heard by himself and counsel regarding Section 14 of Article 3, that's only in criminal proceedings, so the right to counsel is not present in administrative proceedings. Also, exhaustion of administrative remedies, so it's in this case in Kudia versus Superintendent of the PMA, and it was held that yes, they had exhausted all administrative remedies. So, yeah. Anyway, not super important. Now let's go to DENR, Penro of Virac versus Eastern Island Shipping Line. So I'll run through this also because it's a Gerlan case. So here the issue was whether or not Eastern Island Shipping Lines was denied its right to due process when the RTC ordered the confiscation of its vessels without proof that it knew or participated in the unlawful use of the truck. Now, I remember discussing this also a lot in admin law because of the whole taking thing, you know, and how do you get the truck back? How do you argue to get the truck back? I remember we covered that for a while, so just trigger that in your brain, Ali. So this was a criminal case because it's not just DENR Penro, it's also People of the Philippines versus Eastern Island Shipping Corporation. So it's a criminal case for a violation of the Forestry Code. It was illegally taken logs, illegally cut down logs. And then what they used to move the logs around were the trucks owned by Eastern Shipping. Eastern Island Shipping didn't do the illegal logging, okay? But their truck was also taken. Or impounded. It was impounded by the DENR. So, like, you know, it was used in the commission of the crime, but it's the private property, not of the person who committed the crime, but it's Eastern Island Shipping. So, now they're just out a truck. And you shouldn't be able to impound it just because you want to, because it's private property, and then, right, you're protected life, liberty, property. So, here the Supreme Court didn't rule, though, if there was any unlawful taking by the impounding of the truck. Instead, the court just said to remand it down to the RTC to allow Eastern Shipping to prove that the court had no right to seize the property. Like, they didn't say, yo, DNR, return the truck. So it was just remanded down. So, whether or not the taking of the DNR was lawful wasn't actually discussed in this case. So, but for due process, the Supreme Court, through Justice Kirlan, did rule that the Eastern Shipping Lines was denied due process. Although PD number 705, which is against the illegal logging, baba, is a special law, it does not prohibit the suppletory application of Article 45 of the Revised Penal Code, which allows confiscation of instruments used in a crime, except when they belong to a third person not liable for the offense. So since the truck was owned by a corporation not charged in the criminal case, then the forfeiture of their truck, their private property, even though it was used as an instrument for the crime, could not automatically be ordered without first establishing that the company had knowledge or participation in the crime, hence it being remanded down to the RTC to allow Eastern Shipping to show that, they didn't have any knowledge or participation, and thus there was no right to take the truck. Absent such proof, and without giving the company a proper opportunity to present evidence, the confiscation violated its constitutional right not to be deprived of property without due process of law. So, another thing to note here is that judicial confiscation can be ordered by the courts as an accessory penalty. Still, though, you have to respect the rights of third-party owners. So the RTC actually committed a grave abuse of discretion by denying the reopening of the proceedings on the confiscation, hence remanded again. But yeah, the Supreme Court didn't order the release of the truck. Instead, they remanded the case down to the trial court to allow for the proper presentation of evidence regarding the ownership of the truck and the lack of knowledge. So therefore, that would ensure observation of due process. Now, void for vagueness, again, this is closely intertwined with the right to due process, because the void for vagueness doctrine holds that a law is facially invalid if men of common, I think I was saying average earlier, if men of common intelligence must necessarily guess at its meaning and differ as to its application. Normally, the following factors affect the validity of the law when the void for vagueness doctrine is applied. So what are you going to look at? The ambiguity of the terms used. If the law lacks clear standards or definitions, then its application would become confusing. You could have arbitrary enforcement on the part of law enforcement officers because they get to decide what is illegal because the ambiguous terms lack clear standards or definitions. You would have a violation of due process because you wouldn't be notified, right? How can you be notified of the consequences of your actions if you didn't even know that your actions would be unlawful? So the law would be ambiguous when it denies the person the information as to the consequences of their actions in the application of the law. Am I doing something unlawful right now? I don't know. So that's a violation of due process. It's too ambiguous. The opportunity for arbitrary enforcement. When the law lacks clear standards, it results in the selective application of the law, leading to wrongful prosecution and the possibility of a chilling effect on constitutionally protected rights. So when the law lacks any clarity, it could cause individuals not to fully enjoy their constitutionally protected rights out of fear of any penalty when they act under the provisions of the law. So what I talked about to myself while sitting in a field earlier. Again, the case of Decini versus Secretary of Justice, the court allowed an exception to the general rule that penal statutes are not subject to facial challenges. So, the as-applied doctrine, it's applied again to a specific person, and then that person brings to the court the specific provision that is violating their right. But, the as-applied doctrine is... that's the as-applied doctrine, right? But then in the Decini case, he said facial challenge is also okay because the petitioner here was able to mount a facial challenge to the constitutionality of a statute, even if he claimed no violation of his own rights under the assailed statute, because it involved free speech and the grounds overbreadth or void for vagueness. Okay? Overbreadth or vagueness. The statute is too broad, it is too vague. So, in Decini versus SOJ, for the Cybercrime Prevention Act, the specific terms being questioned were the void terms were ruled to be under Section 12 and Section 5. Section 12 was due cause, and Section 5 was aiding or abetting. So, like, if you just like or share someone's post, is that aiding or abetting? So that's not fair notice. You don't know if your specific online conduct is criminal or is this lawful, you know? So for Section 12, the due cause, the court struck it down as it had no precedent in law, since the provision in the cybercrime law did not require that data collection be tied to the probable commission of a particular crime. Thus, it would effectively be a license for general surveillance rather than targeted crime-specific monitoring. So this was in Section 12 talks about real-time data, traffic data collection. So basically, like, those two things. So in Decini versus Secretary of Justice, they were able to prove that the Cybercrime Act, with these void terms, would give a chilling effect. And the chilling effect also is, again, in Calleja versus Executive Secretary, where the court, despite ruling that the Anti-Terrorism Act is unconstitutional, still held that some provisions are ambiguous and thus vague, and thus should be void, because they would give a chilling effect for being overbroad, because in the end, this is all a violation of freedom of speech, expression, and the press. Remember the two principles that would govern the interpretation of statutes or actions of the government that would unduly intrude upon the constitutionally protected right of free speech: void for vagueness, overbreadth. Okay. Now, one last thing to cover here for due process, which I just want to touch on real quick: judicial and administrative due process. Judicial due process has 4 requisites, whereas administrative due process has the Antibay versus CIR case, which has 7, right? So running through them real quick, just to throw this here so that due process is complete. Requisites for judicial due process: it must be an impartial court or tribunal clothed with the judicial power to hear and decide the matter before it. Second, jurisdiction must be lawfully acquired over the person of the defendant or the property subject to the proceedings. Third, the defendant must be given the opportunity to be heard. And fourth, judgment must be rendered only after lawful hearing. So again, requisites of judicial due process: an impartial court clothed with judicial power to hear and decide the subject matter before it. Second, jurisdiction lawfully acquired over the defendant or the property subject to the proceedings. Third, the defendant is given an opportunity to be heard. And fourth, the judgment must be rendered only after a lawful hearing. So to sum it up, an impartial court with the competency or the jurisdiction over the subject matter before it. Second, jurisdiction over the defendant or the property. So, yeah, the property subject to the proceedings. Third, right opportunity to be heard by the defendant. And fourth, the judgment would only be rendered after the lawful hearing. Then the requisites for administrative due process: we should all know this by heart. Right to a hearing, that the tribunal must consider the evidence presented, which is, side note, I like to think of it as the requisites for administrative due process rather than the cardinal rights, because is it a right to have the tribunal consider the evidence presented before it, or is that an obligation upon the tribunal? I don't know. The way it's put in ang tibay, I know it is the most common one, but there are other cases that use different formulations of the rights to due process under administrative proceedings. Okay, there are other formulations. JBL even has one. I think it's only 4. Anyway, let's just run through it. Whatever. The party has a right to a hearing. The tribunal must consider the evidence presented. The decision must have something to support it. The evidence must be substantial. The decision must be rendered on the evidence presented at the hearing, or at least contained in the record and disclosed. The hearing officer must act on his or her independent consideration of the law and facts of the controversy, and not simply accept the views of a subordinate in arriving at the decision. So, like, for this one, there were the cases of, like, so it was elevated to, like, the secretary, and then they agreed with the decision below. That's okay, so long as they actually consider the facts and then they're like, yeah, you make sense. Instead of just, this is your decision, I'm gonna just rubber stamp it, right? We don't want that. But we also can't have the secretary to, I mean, I don't think they have the time to decide everything. But if someone already makes the decision for them and they can just consider it there instead of, you know what I mean. I know what I mean. Whatever. And then lastly, the board or body should, in all controversial questions, render its decision in such a manner that the parties to the proceeding can know the various issues involved and the reason for the decision rendered. Otherwise stated, the ang tibay doctrine would be, so, ang tibay versus CAR, cardinal primary requirements, there we go, cardinal primary requirements for procedural due process in admin proceedings. Whatever. Right to a hearing, this includes the right to present one's case, submit evidence in support thereof. The tribunal should then consider this evidence. The decision rendered by the tribunal should have something to support itself. The evidence has to be substantial. Substantial evidence means what? From memory. Reasonable evidence, as a reasonable mind might accept as adequate to support a conclusion. So, substantial evidence, reasonable mind would take reasonable evidence to support a conclusion. The decision must also be based on the evidence, so, which is different from the decision must have something to support itself, okay? The decision has to be based on the evidence, and there also has to be some sort of, like, a regulation. Is the decision based on, like, say, company policies, right? There. So you take the evidence, you apply to the company policy, and then you have your decision. So the fifth one is the decision must be based on evidence which is presented at the hearing or at least contained in the record and disclosed to the parties affected. Because if it's based on something else or evidence outside that the admin body just got from somewhere else, how are you supposed to prepare your defense against that, right? You didn't even know. You didn't even know it was being taken into account. And then 6, the tribunal or body or any of its judges must act on their own independent consideration of the law and the facts of the controversy and not simply accept the view of a subordinate. And then lastly, in the case of all controversial questions, the board or body should render its decision in such a manner that the parties to the proceeding can know the various issues involved and the reasons for the decision rendered. Okay, so that's due process, the first of the constitutional rights. Nice.